Welcome to my RPA Purchase Agreement Fundamentals training series. In this comprehensive course, we will cover the essential building blocks every real estate professional needs to master when completing California residential purchase agreements. This series focuses on the foundational elements that make or break successful transactions. We'll start with proper communication protocols, explaining when to use text messages versus email, and why documentation is crucial for legal protection. You will learn why the date prepared on your purchase agreement is so critical and how it affects every other form in your transaction. We'll dive deep into pre-offer preparation requirements, including how to pull and verify comparables, property profiles, and why checking MLS information against county records can save your clients thousands of dollars. I will show you real examples of how square footage and bedroom count discrepancies can derail deals. Agency disclosure and confirmation rules will be thoroughly explained, including dual agency requirements and how to properly document representation relationships. You will understand exactly when dual agency applies and how to avoid common mistakes that lead to DRE issues. Transaction coordinator limitations and professional responsibilities are covered in detail, including why you should never let unlicensed assistants complete legal documents. We will explore purchase price and financing basics, offer expiration timing, and critical filing requirements. Initial deposit rules, including California's 3% maximum limit and liquidated damages calculations, are explained with practical examples. You will master the 3-day deposit deadline and understand why agents can never touch client money under any circumstances. Loan information, calculations, and special FHA/VA requirements round out this foundational training. By the end of this series, you will have the knowledge and confidence to complete purchase agreements professionally and protect your clients' interests. Remember, this is educational content based on my experience. Always consult with your broker for specific legal guidance. Now, if you are eager to dive right in and begin your training, go ahead and click that subscribe button. And if you find this information helpful, please do not hesitate to share for more insightful real estate content. Thanks for joining me in this training series. I look forward to seeing you in our next video.
Residential Purchase Agreement Fundamentals. The date prepared on your purchase agreement is absolutely critical and often overlooked by new agents. This date becomes the reference date for all other forms throughout the entire transaction process. When you complete other forms during the transaction, they will ask for addendum to purchase contract dated, and this refers to the date prepared on the original purchase agreement, not the current date when you're filling out the addendum. This is a common mistake that can cause confusion and legal issues. Before writing any offer, you must complete essential preparation steps. First, pull comparables and review them with your buyer so they understand the market value and can make an informed decision about their offer price. Second, pull the property profile from your title rep using their free program or from the MLS Realist section. The property profile information includes the assessor parcel number, accurate bedroom and bathroom counts, year built, and owner names, which are critical for filling out forms correctly. This preparation work must be completed before presenting any offer. Too many agents rush to write offers without doing proper research, which leads to problems later in the transaction. Your clients are depending on you to provide accurate information and professional guidance. Taking time for proper preparation protects your clients' interests and demonstrates your professionalism. It also helps you write stronger, more competitive offers because you understand the property's true value and any potential issues that need to be addressed. Critical verification requirements. Here's a real example that demonstrates why property profile verification is absolutely essential. The MLS showed 4 bedrooms and 2,000 square feet, but the property profile showed only 3 bedrooms and 1,800 square feet. This discrepancy reveals a serious issue that affects both value and financing. What this means is that the additional room or bedroom may have been added without proper permits. The county assessor only counts permitted rooms in their official records, which is what appears in the property profile. Even if the house actually measures 2,000 square feet, if the property profile shows 1,800 square feet and there are no permits for the addition, it only counts as 1,800 square feet for appraisal and valuation purposes. This significantly impacts the home's value and can create major problems with financing. Unpermitted additions don't add to appraised value and can create financing issues because lenders rely on county records for their valuations. Your buyer could end up paying for square footage that doesn't legally exist according to official records. The timing of this verification is critical. You must check this before writing the offer, not after. Once you discover these discrepancies after the offer is submitted, it becomes much more complicated and expensive to address the issues. Always verify MLS information against official property profiles to protect your buyers from overpaying based on inaccurate square footage or room counts. This simple step can save your clients thousands of dollars and prevent transaction failures. Agency disclosure and confirmation. Section 2B requires complete and accurate agency information for both sides of the transaction. You must include the seller's brokerage name, seller's agent name and license number, buyer's brokerage name, and buyer's agent name and license number. Understanding dual agency rules is critical. If both agents work for the same corporation, this creates dual agency regardless of whether they're different agents. For example, if both agents work for ABC Realty of California Inc., even though they're different people, it's still dual agency because they work for the same corporate entity. In this case, check both boxes for buyer and seller dual agent. Different corporations mean separate representation. For example, if the listing agent works for ABC Realty of California Inc. and the buyer's agent works for ABC Realty of Southern California Inc., these are different companies with different DRE numbers and different brokers. Each has a separate corporate identity, so you would check that one agent represents the seller and the other represents the buyer. The key point is that different DRE numbers mean different corporate entities. You need to be very specific about which corporate entity your license hangs under. Don't just write ABC Realty, specify which exact legal entities such as ABC Realty of California Inc. For clarity and legal protection, always specify which entity you're referring to. Be super clear about which corporate entity your license hangs under to avoid any confusion that could lead to DRE issues or legal problems later in the transaction. Transaction Coordinator Rules. Here's a critical warning that can save your license. Do not have your transaction coordinator fill out legal documents. This is one of the most dangerous shortcuts agents take, and it leads to serious problems. Why this is so dangerous becomes clear when you understand the legal responsibilities. You are the licensed agent, which means all documents are your responsibility regardless of who physically fills them out. You must personally review all documents before they go out to other parties. Real consequences happen when transaction coordinators fill out documents incorrectly and those documents get sent out, leading to DRE investigations. The agent's excuse of saying they didn't fill it out, their TC did, actually creates a double problem. Problem 1 is that the TC filled it out wrong, and problem 2 is that the agent didn't review it before sending. The transaction coordinator's proper role is to provide administrative support and ensure paperwork gets where it needs to go after you've completed your part. You supervise them to ensure they did what they were supposed to do, but you maintain full responsibility for accuracy and completeness. You get paid well in real estate because you take on significant responsibilities. One single home sale could cover all your bills for a month or more. But there are serious responsibilities that come with that compensation level. Remember that you cannot be protected from liability if you're looking for shortcuts. Review everything personally before it goes out to protect yourself and your clients. Purchase price and financing. Let's work through purchase price and financing using $650,000 as our example purchase price. Understanding these basics properly will help you complete contracts accurately and avoid common mistakes. For all cash transactions, you must check the all cash box clearly. For transactions requiring financing, do not check the all cash box. The default assumption in the contract is that if the all cash box is not checked, financing is needed for the transaction. The close of escrow timing is typically 30 days after acceptance, though this can vary based on financing type and other factors. Make sure this timeline works for both your buyer's financing needs and the seller's moving requirements. Offer expiration gives you two main options. You can set a specific date and time such as September 14th at 5 p.m. or September 14th at 12 p.m. noon. You can choose any specific time and date that works for your strategy and market conditions. If you don't fill in a specific expiration date, the contract defaults to 3 calendar days after all buyers sign at 5 p.m. Here's how the timeline works. If buyers sign today, which counts as day 0, then Thursday is day 1, Friday is day 2, and Saturday is day 3, so the offer expires Saturday at 5 p.m. Always be very clear about expiration timing to avoid confusion and potential disputes. Both agents need to understand exactly when the deadline occurs so they can advise their clients properly about response timing. Offer expiration and filing requirements. Post-expiration options and filing requirements. When an offer expires, you have several options available. First, both parties can reach a mutual agreement to proceed despite the expiration. Second, either party can walk away after expiration with no further obligations. Third, as a best practice, even if the offer has expired, send a formal withdrawal of offer if your buyer wants to move on to other properties. Filing requirements are strict and must be followed regardless of the offer outcome. All signed documentation must be kept in your files for 3 years minimum. This includes rejected offers which go in your file specifically marked as rejected offers. Expired offers still must be filed and maintained for the full 3-year period. An important rule about timing: original offers cannot be reused after significant time has passed. If parties want to proceed after the offer has been expired for weeks, you must write a completely new offer rather than trying to revive the old one. For timing guidance, if an offer expires and parties want to proceed the same day or next day, you may proceed with the expired offer if both parties reach mutual agreement. However, if 3 weeks have passed, that's way too long and you must write a new offer to protect all parties. Proper documentation and timing requirements protect all parties involved and ensure compliance with real estate regulations. Keep detailed records of all offers regardless of their outcome because you never know when you'll need to reference them for legal or regulatory purposes. Initial deposit rules and limits. California state law establishes clear limits for initial deposits. The initial deposit cannot exceed 3% of the agreed-upon purchase price for 1 to 4 unit properties. The only exception to this rule is probate sales, which may require up to 10% as an initial deposit. From a strategic standpoint as a buyer's agent, you should question why you would tie up more money than the legal maximum of 3%. Requiring more than necessary is typically not in your buyer's best financial interest and may indicate inexperience. For competitive market situations, using the maximum 3% deposit shows the strongest financial commitment within legal limits. When presenting options to your buyer, you might say something like, "We really want this house and want our offer to stand out." One strategy would be to put the maximum amount for initial deposit at 3% to show strong commitment. Understanding liquidated damages is crucial for protecting your clients. California law states that the maximum amount a seller can retain if a buyer defaults is 3% of the purchase price or the actual deposit amount, whichever is less. Here's a practical example. If the purchase price is $800,000 and the buyer puts down a 2% deposit of $16,000, if the buyer defaults, the seller can only keep the actual $16,000 deposit, not the full 3% maximum, which would be $24,000. Your professional role is to present all available options to your clients and let them make the final decision about deposit strategy based on their specific circumstances and comfort level. Deposit timeline and money handling. The deposit must be placed into escrow within 3 business days after acceptance of the offer. We use business days because escrow offices aren't usually open on weekends and holidays, so those days don't count toward the deadline. Here's how the timeline works with a practical example. If an offer is accepted on Thursday, that Thursday counts as day 0. Friday becomes day 1, which is the first business day. Saturday and Sunday are not business days, so they don't count. Monday becomes day 2, and Tuesday becomes day 3. The deadline is the end of business on Tuesday. Getting the deposit in on the first business day is much better if at all possible, as it shows good faith and eliminates any potential complications from the deadline. Money handling restrictions are absolute and cannot be violated under any circumstances. As a real estate agent, you cannot touch client money for any reason whatsoever. This applies to all scenarios regardless of how reasonable they might seem. Common scenarios include clients asking you to take their check to escrow because they'll be out of town, asking you to pay an inspector on their behalf, or any other money handling request. The answer is always no because agents do not have trust accounts or trust logs required for handling client funds. If a buyer fails to get their deposit into escrow within the 3 business day deadline, they are in default. The seller can then issue a notice to perform, and if the issue isn't corrected during the notice period, the buyer can lose the house entirely. Loan information and calculations. Let's work through loan calculations using our $800,000 purchase price example. With a 20% down payment, the buyer puts down $160,000 and needs a loan amount of $640,000, which represents 80% of the purchase price. Always verify your math using this checking formula. The balance of down payment after subtracting the initial deposit is $136,000. Add the loan amount of $640,000 plus the initial deposit of $24,000, and your total should equal the purchase price of $800,000. The default loan type is a fixed-rate conventional loan unless you specify otherwise by checking different boxes or filling in other loan types like USDA loans in the other category. Points and closing costs require coordination with the lender to determine what the buyer is willing to pay. As a strategic consideration, when asking the seller to pay closing costs, put 0 points for the buyer to make the request more reasonable. FHA and VA loans have special requirements you must understand. If your buyer is using FHA or VA financing, you must deliver the lender-required repairs list within 17 days after acceptance. The process works when the appraiser provides a list of lender-required repairs based on their inspection of the house. Property occupancy affects loan terms significantly. The default selection is primary residence, but you can also select secondary home or investment property. Each designation affects the lender's requirements and interest rates. After closing, borrowers can change how they use the property, but the initial designation must be accurate for loan approval.
All right, team, as we wrap up this session, I want to leave you with a crucial piece of professional advice that will serve you throughout your entire real estate career. Think of it as the foundation upon which you'll build your success and protect your practice. What we've covered today is powerful, educational guidance drawn from years of hands-on, in-the-trenches experience. These strategies and insights are designed to give you a competitive edge and a clearer path forward. However, it's absolutely vital to remember that the world of real estate is not static. It's a living, breathing entity that is constantly evolving. Laws, regulations, local ordinances, and standard procedures are always in motion. What was standard practice last year might be outdated today. A new piece of legislation can change how we handle disclosures, and a court ruling can redefine contractual obligations overnight. This is why your journey of learning never, ever stops. Your most trusted ally in navigating this complex landscape is your broker. They are your primary resource for compliance and your first point of contact for any procedural questions. Before you implement any new strategy or face a tricky situation, your first step should always be to verify the current requirements and best practices with your brokerage. They have the systems and oversight in place to ensure you are operating correctly and protecting both yourself and your clients. Please remember that we are real estate professionals, not attorneys. When you encounter a situation that involves complex legal questions, whether it's about title, estate issues, or unique contract clauses, it is your professional duty to advise your clients to seek legal counsel. Never attempt to interpret the law or provide legal advice. Your role is to recognize when a legal professional is needed and make that referral. This protects your clients, and it protects you from significant liability. Partnering with a good real estate attorney can be one of the smartest business relationships you build. Finally, I want to urge you to be a lifelong student of this industry. Make continuing education a priority, not just a requirement to renew your license. Actively follow regulatory news, subscribe to industry publications, and participate in workshops. Staying informed about the changes that affect our practice is not just a good idea, it is an essential part of your professional responsibility. The most successful agents are always the most informed agents. Thank you so much for your time and your incredible engagement today. I hope you found this training valuable. If you did, please hit that like button and subscribe for more content to help you build a thriving real estate business. Now go out there and make it happen.